Stuart Alderodi gives the U.S. Securities and Exchange Commission its most brutal fight against crypto regulation in one of the industry's most important tests, even as the failure of FTX influences the world of digital asset trading. Alderodi, a 63-year-old lawyer, has spent most of his career working for traditional financial players. As the chief legal officer of payments firm Ripple Labs Inc., he is currently at the center of litigation and a bitter public relations battle against the SEC and its president Gary Gensler. The Ripple case is a pivotal element in the growing debate over regulating an industry that is sometimes compared to the Wild West. It may soon enter a new phase. A federal judge is looking into dueling moves from Ripple and the SEC, each of which is demanding that the case be settled in its favor. Ripple claims to have spent about $100 million defending the lawsuit and, in fact, protecting the entire crypto industry from what it calls over-regulation by the SEC. Alderodi turned to a list of prominent outside attorneys, including Obama administration SEC chair Mary Jo White and her former deputy Andrew Sarezny. Meanwhile, with the crypto winter sweeping through digital asset markets this year and the famous crash of FTX, the SEC is working to protect investors. Tibor Nagy, a New York-based attorney who has represented clients of the crypto industry, said the case against Ripple, which is closely watched by the SEC, is expected to deliver a final verdict on whether crypto assets are securities or not. The SEC alleges Ripple CEO Bradley Garlinghouse and co-founder Christian Larson of the San Francisco-based company misled investors by failing to register Ripple's XRP, one of the 10 crypto tokens. Ripple has raised more than $1.3 billion through an unregistered token offering, the agency said in its lawsuit filed in December 2020. The company argues that XRP is not an investment contract and is therefore not subject to a regulatory authority. Ripple says allowing the SEC to regulate tokens as securities opens the door to treating other assets like cars, diamonds, and soybeans as securities. The SEC feels justified in its approach to crypto regulation. The agency announced on November 15th, 4 days after FTX filed for bankruptcy, that it had initiated 760 enforcement actions this year, resulting in a record $6.4 billion in fines and recovery for investors, up 64% from 2021. Recently, the Blockchain Association filed an amicus brief in the SEC's lawsuit against Ripple. The association's attorneys, along with other friends of litigants like John Deaton, argued that downstream buyers of cryptocurrencies and tokens don't necessarily invest in securities or not enter into an investment contract. It is, therefore, interesting that these petitioners do not object to the SEC's claim that Ripple initially sold XRP-USD, as an unregistered security. Instead, they argue that there is a clear limit to applying applicable securities regulations to digital assets and a limit to using the Howey test for coins and tokens. Announcements because, by their very nature, they need to adapt to outdated regulations readily. The regime was established in 1946. The memoir conveys some points that make up the contrast between was and are, and the article below considers some of the ideas included and how the court's decision can aid XRP and the broader crypto industry through regulatory clarity. A finding that XRP is not a security will likely have wide positive ramifications for crypto legislation, general institutional adoption, and the valuation of cap altcoins. In the SEC versus Howey, the Supreme Court held that an investment contract for the purposes of securities law means a contract, transaction, or scheme whereby a person invests his or her money in a common enterprise and only benefits from the efforts of the promoter or a third party. The language of the Supreme Court in Howey should be taken literally. An investment contract requires a real investment to be considered tangible. Intangible assets cannot suffice, as such concepts can include everything. Accordingly, even if the court found that some participants had purchased XRP with the expectation of making a profit, the association respectfully requests the court to avoid discovering that, out of necessity, all buyers in the XRP market expect to profit. When discussing the Howey test, many of the previous arguments from crypto advocates have focused on the decentralized nature of cryptocurrency platforms and their development. These arguments rightly indicate that sponsor or third party is often more challenging to identify than is required in the test, and the statements above add to these problems for the SEC's position, notably by undermining expectations of returns from the experimental arm relative to those buying the asset downstream. A Forbes article titled "Cryptocurrency Law Experts Suggest SEC Likely to Lose Key Case and Discredit Howey Test" proves that lawyers outside the crypto industry tend to agree with the points outlined in the Blockchain Consortium's amicus brief. And if the court accepts, the above documents will provide a regulatory analysis of the security definition for XRP, similarly positioned coins and tokens, and the digital asset markets trading them. One possible outcome is that Ripple, which directly stated its willingness to settle, pays a relatively hefty fine, but Ripple will ask for an agreement or ruling that XRP is not a security. This outcome will likely allow XRP to be listed on digital asset exchanges like Coinbase Coin. For this reason, a constructive case resolution may not be a sell-in event, as new demand channels may emerge shortly after the resolution. Gary Gensler missed it again. After his agency failed to warn investors about Terra and Celsius, their collapse this spring wiped out a $1 trillion investor. The chairman of the Securities and Exchange Commission had left an even more significant setback before his eyes. Of course, I'm talking about this week's revelation that a $30 billion FTX empire is a house of cards, and its golden boy founder, Sam Bankman-Fried, is the crypto equivalent of Elizabeth Holmes of Theranos. To be fair, Gensler wasn't the only one intrigued by SBF. Almost everyone, myself included, fell in love with the story that SBF, with its adorable Afro attitude and creepy stuff, was precisely the savior cryptocurrency needed to get out of its dodgy reputation, its own, and emerge in the traditional financial system. The unruly Gensler needs to spot the crime, but he also seems willing to follow a legislative strategy that could give SBF a legal edge and make him the king of the U.S. electronic money market. According to Washington insiders I spoke to, SBF decided to take control of BlockFi this summer to benefit from the struggling crypto lender's recent settlement with the SEC, which is extending the amnesty that BlockFi received at FTX. Meanwhile, FTX's recent partnership with the stock exchange IEX of the famous Flash Boys will also help SBF's empire fall under the auspices of the United States. This will allow FTX to dominate the U.S. market as the company pushes for legislation that could knock out competitors like Binance and the emerging DeFi sector. Gensler, Hillary Clinton's former chairman of campaign finance, is not the only prominent Democrat who might be willing to exert influence on behalf of FTX. You may recall that SBF is one of President Joe Biden's biggest donors, while his parents, Stanford law professors, have party ties. His mother, Barbara Fried, runs a group called Mind the Gap that helps raise funds in Silicon Valley for the Democratic Party, while his father, Joseph Bankman, drafts tax legislation for Senator Elizabeth Warren, a Democrat from Massachusetts. It is no exaggeration to imagine that SBF sought to exploit these political links to his advantage. This does not mean that SBF, Gensler, and top Democratic Party officials have been sitting around a clear plan to hand over the crypto industry to FTX. This stinks too much of a wild conspiracy theory. However, when Gensler calls for more money and power to deal with the latest crypto crisis, now would be a good time for skeptics to question why he can't prevent FTX in the first place, and if anyone else is high. Locations played a role in this failure. In an interview with reporters for the Washington Post, Gensler defended the SEC, saying it had filed several enforcement cases focusing on those with broader impact and across exchanges, where unregistered coins are most commonly exchanged. "I couldn't be more proud of this agency," he said. According to Cornerstone Research, the SEC filed lawsuits against unlisted coins 44 times between 2013 and 2021. These lawsuits represent less than 1% of unlisted coins. Gensler noted that tracking exchanges take time, adding that complex investigations often take nearly 2 years. He said more customers would benefit if the SEC could prevail in such cases. That's where you can get maximum investor protection if you can get them to comply, Gensler said. Deeply invested crypto companies, some of which Gensler described as well-resourced, deeply legitimate, have fought long and complicated court battles to resist or at least delay the SEC's enforcement. The agency has also been criticized by some members of Congress, led by Representative Tom Emmer. A bipartisan letter to Gensler in March argued that the agency harassed cryptocurrency exchanges in a manner inconsistent with request for investigative information. Let us know your thoughts in the comments section, and to stay updated, make sure to click the subscribe button.